Okay, thank you so much for joining us for today's webinar, a practical guide to total and permanent disability, psychosocial disability claims, financial relief for permanent disablement, ill or injured. My name's Carly Hansen. I'm one of the Sector Sustainability Coordinators at Community Legal Centres Queensland. I'd like to firstly acknowledge the traditional owners of the land on which we're holding today's webinar. In Meanjin, Brisbane, where CLCQ's office is based, they are the Turrbal and the Yagara people. I wish to pay my respect to their elders, past, present and emerging, and acknowledge that these are stolen lands and that sovereignty was never ceded. As today's webinar is being viewed by people throughout Queensland and Australia, and we've got our presenters coming to you from New South Wales, I'd also like to pay respect to the traditional owners throughout the country and extend a very warm welcome to any First Nations people who are listening in to the presentation today. So I'm really pleased to welcome our presenters, David Curry, Special Counsel at Carroll and O'Dea Lawyers, who will be presenting with Natalie Ross, Principal Solicitor from the Welfare Rights Centre in New South Wales. They'll be talking to us, as I mentioned, around TPD claims for psychosocial disability. To introduce the session, many people who are permanently ill or injured due to a mental health condition will have worked at some time during their lives. However, ASIC reports that a significant number of people do not know that they might be able to claim for TPD cover through their superannuation. ASIC also reports that claims for mental illnesses are refused at high rates. So today's webinar will seek to identify some of the practical issues in identifying and running these important TPD claims across 3 areas. So there'll be the checklist, which is the TPD mental health assessment, navigating the TPD path, and looking at outcomes for clients. So I'll let David and Natalie tell you a little bit more about themselves when I hand over in just a moment. But before I do that, some quick housekeeping. Today's webinar is being recorded. I'll have the recording available for you to download later today. The PowerPoints in a PDF format have been emailed out to everyone this morning and are also available to download from our website and from the handout section of the GoToWebinar control panel if you missed that email. We encourage you to ask questions, so simply type your question into the question box on the GoToWebinar control panel and I'll read your question out. We'll hold those questions to the end of the presentation, but feel free to type them in as you think of them. There is quite a bit of content to get through today. There are also just a couple of quick polls at the beginning of the session, so when they pop up on the screen, pop your answers in. That will really help our presenters. So I'll now hand over to David and Natalie to get us started. Thanks so much.
Thanks, Carly. Hi, everyone. I'm David Curry, and I'm Special Counsel at Carroll and O'Dea Solicitors, and I'm here with Natalie Ross.
Hi, everyone. I'm Natalie Ross. I'm Principal Solicitor at the Welfare Rights Centre here in New South Wales.
I'd firstly like to begin by acknowledging the traditional owners on the land in which we meet today, and I would like to pay my respects to elders past, present and emerging. So thanks everyone for joining us today. You might have seen we've got quite a few slides to get through, but I guess I'd just like to firstly flag that, look, the session will run hopefully with some more detail in relation to the awareness of the issues that relate to TPD, and some of the slides in the second half of the presentation will be there for you by way of background and context. So we might be going a little bit quicker through the second half of the presentation simply because I think some of the issues around the nature of what TPD is and how it might relate to your casework are some of the important aspects of what we were trying to share today. And on that note, we thought it might be good and useful to start with an interactive poll. And so we've got, excuse me, 2 questions here for you to answer if that's okay. The first is, have you run a TPD claim? If you could just share for us whether you've done one of these things before. And the second is, have you ever run, we're calling it an appeal, it's probably better put as like a rejected claim TPD matter, and that could have been run either through an IDR process or possibly through AFCA, a process like that. And so we'll just wait for a second to see what people share with us in relation to this.
Great, so that first poll's up on the screen and we've got most people have voted, so I'll give you another 5 seconds to pop your response in and then I'll share those results. All right, so I'll just close that poll and get the results up. So hopefully you can see that. So 13% have said yes and 87% have said no. So I'll now pop the second poll up for you. So again, maybe 30 seconds to pop your vote in. Okay, and I'll close that poll now and share those results. So 4% as a yes and 96% no.
Well, David, that certainly chimes with my previous experience working in generalist community legal centres in New South Wales, where TPD didn't really form part of our work at all. So we've got a lot to learn.
Yeah, and it's a really important issue, because we know that ASIC says that TPD plays a very crucial role in what it describes as the safety net of financial security for Australians. There was a really seminal report, 633, called Holes in the Safety Net, where ASIC went through only recently a review of TPD claims in Australia. The report is really useful for a number of reasons, but probably the most important one, I think, is that it reports that more than 90% of all Australians have actually got what's called default TPD cover, which is the cover that sits in the super, in your superannuation. And so the reason why this is connected to employment is because if your client has ever worked at any point, at some level, it's more than likely that their employer has made contributions into a super fund. And if they've made contributions into a super fund, it's more than likely that the super fund has gone out into the marketplace and purchased what's called group life insurance on behalf of those members. And so that's how come the product arises. And it's probably the reason why, Natalie, we're seeing that there is probably low levels of awareness in relation to the cover, because our clients and ourselves, even as employees, haven't gone into the marketplace to get this product. It's been obtained for us, for our benefit, by super funds, but not necessarily well known, I think. And so there is a big access to justice issue here, in my view. We know that in 2018, approximately 26,000 people were approved for DSP. And in the same year, almost the same number of people actually applied in relation to TPD. And I think that's a really interesting correlation between two systems of benefit and safety net that exist in Australia. But I think there's a very big correlation here between the nature of people that become permanently disabled and need to access the public system, but also this system is also available for a lot of the clients who you might see in your casework practice. And so if you have issues as the presentation goes along where you're wondering, is this a relevant matter for TPD, please feel free to share. We're going to pick up the questions and answer them at the end. But just while I think about it, I think probably the biggest access to justice question that might come up relates to the fact that TPD is a product that sits across the nature of people's employment. And so you can have a TPD claim that's what might be described as a historical claim. So it doesn't necessarily relate to whether or not someone is not working at the moment, although that can be relevant. I certainly was just sharing with Natalie that we had a case that I'm running at the moment where my client was actually disabled in 2007, and he approached us seeking a refund for those insurance premiums. We advised him that because he hadn't worked since that date, he actually had a TPD claim, 2 TPD claims to make, and is now putting forward those claims at the moment that are worth up to $500,000.
Yeah, so that really hit home for me, David, that as community legal centre lawyers, we really need to be aware of this potential for clients to claim what can be very substantial amounts of money and could make a huge difference to their lives.
Yeah. So where we see ASIC buying into this debate, they really do seek to connect this to employment and to the nature of employment, and to advise that this really is a significant issue in the Australian public's awareness, in that so many people really don't know that when they become ill or injured, and these are the words in a TPD policy, ill or injured, that they may have some basis to claim for TPD, which is a no-fault based insurance system. The reason why it's an access to justice issue is, of course, that a lot of people do drop out of the TPD claims processes. These are actually the refused rates, which run from something like 9% to 29% amongst insurers. But you might say, and this was certainly ASIC's finding, that similar numbers of people drop out on what might be called withdrawn claims for TPD. So that's someone that started the process and got stuck and weren't able to make their way through it. And so that's certainly one of the biggest issues in a TPD claim, which can be of itself a challenging process that can take somewhere between 3 to 6 months to go through.
That sounds analogous to the difficulties people have trying to get onto disability support pension, when so many people just can't make their way through that process.
Yes, and that was certainly my experience at Legal Aid, was that a lot of people would be challenged in the technical aspects of meeting the requirements for disablement in relation to the Centrelink. And so this is a slide that I've come up with that is really just it's just a mind map, but the idea here is for us just to be thinking about the context in which we each of ourselves service our client base. Of course, the work that I do is in the TPD space, and my background is that I work in a practice in Parramatta where we have a lot of people that are ill or injured through workplace injury or accidents. And so we see a lot of the work in that context, but certainly there's other contexts here for people to think about this work.
Yeah, so as in community legal centres, we're obviously seeing people who have problems with Centrelink and trying to get on disability support pension. I think in recent years we're seeing a lot of people who have struggles with NDIS and are coming to us about that. And obviously many centres do work in employment law and discrimination law where these issues will come up as well.
And employment law is a really big issue in the context even of the cases that we see. We certainly see a lot of people who are in, we see it from the other side, we see people who are in the TPD system that are having their employment law rights affected by a disgruntled employer that seeks to take steps that are adverse to a person's employment. So certainly all of these things appear to me to be quite interrelated. So the session today is intended to highlight what might be described on one version as, at least in terms of TPD policies, these claims would be called mental illness claims. But within the casework practice that you might have from where you stand, I think these claims are probably better described as psychosocial disability claims. And essentially, what we're trying to really do today is to highlight these issues and the policy background to it, and then just to provide you with some tips if you are thinking about running a TPD claim through a claim system. And so the background here is that we have seen significant increase in mental health issues, particularly since COVID. In the last 2 years, a recent study reported that 82% of young Australians have experienced some form of mental health issue in the last 2 years. And there has been a worldwide increase in depression and anxiety triggered by COVID. In the same 2-year period, 49% of all Australians over 25 years experienced some mental health issue. And depression is now a leading cause of disability, and suicide, second leading cause of death amongst 15 to 29-year-olds. In Australia, we know that at least 1 in 5 Australians between 16 and 85 will experience a mental health issue in their life, a mental illness, in their life, and 20% of all Australians in 1 year will experience some form of mental health issue. Almost 45% of all Australians will experience a mental illness in their lifetime. this, I think one of the most shocking facts for me that makes me wonder how our health system is surviving is that GPs across the country are now reporting in a recent survey that 62% of all ailments that come through before GPs are now related to what's described as psychological issues. And this is then followed by respiratory conditions and musculoskeletal issues. And I think that it just shows the level of significance that mental health issues now hold in the Australian community. One of the biggest aspects here, I think, in relation to thinking about psychosocial disability claims, which might be described as sitting on what could be described as a mental health continuum between mental illness and mental health, is that it's certainly not that everyone who experiences a mental health issue will be TPD, and that we are talking about a continuum between people being challenged in their daily lives because they suffer from a condition that does interfere with the way that they feel, think, behave or act, and a condition that is affecting at a level that relates to a diagnosable condition that might be described as a mental illness. And I think that that continuum is, at least within the context of financial services work and the way that the insurers are thinking about it, I think this is a new discussion and a new understanding that insurers are starting to come to realise is a continuum. I don't think that's been well understood within the insurance industry. Within mental health claims, we know that DSM-5 identifies a series of what might be described as mental illnesses, and certainly the ones that have been asterisks there are the more likely conditions, including anxiety and depression, and PTSD certainly being a significant issue for many people that have what's described as a mental illness. The challenge, I think, is whether in fact we have systems that are set up, including legal systems, that are appropriately set up to respond to the level and depth of this crisis that exists in Australia today. And I do wonder whether we actually do have the resources as a country to properly meet the needs that I think we're being challenged to look at the moment. And within the context of systems that we know within the community sector have been challenged for some time. Unfortunately, this is just another issue to think about in terms of the level of disadvantage and strain that is being put on people and systems at the moment.
We certainly find that, particularly with clients in regional and remote areas, just getting access to health practitioners in order to get a diagnosis, which certainly for disability support pension claims is key, and no doubt for TPD claims.
Absolutely.
Well.
Absolutely. No, it's
a huge barrier.
It's such a significant issue. And in fact, we'll come to it in section 2, but you simply cannot bring a claim for TPD unless you do fall within the category of a diagnosable and diagnosed condition and prognosis. And certainly, in my view, without that clear medical evidence and support, that claim really will not go anywhere. So it's a key issue, the mental health, the health issues and the access to proper health treatment. So we know that there are significant issues here in relation to both mental illness and mental health issues that may be manifesting in ways that you might see in your casework practice. What we know in relation to TPD claims is that mental health or psychosocial disability claims now make up the largest portion of all TPD claims. And this was another stat that really shocked me, because I think traditionally it would have been thought that the physical injuries that people suffer, often in the workplace, but it can involve accidents and other reasons, but it's certainly not physical injuries that form the basis of TPD claims. It's worth also noting that ASIC reported in 633 that even though mental health claims are being paid at higher rates, mental health claims are also being refused at higher rates than any other claim. So they're not necessarily easy claims to make. We know in TPD claims that the largest portion of those claims relate to what might be described as reaction to stress events, PTSD and acute stress reaction, and then depressive episode being the next category of claim where TPD is approved for a psychosocial disability claim. In the context of casework, and this is a really important point, I think, for us to think about in the context of how this might come up, because of the issues that we know that relate to people's lack of awareness of what sits within their super, what we might see on a roster or in relation to our work in advising clients, and certainly this is the experience of the solicitors that I work with at Carroll and O'Day in their workers' comp practice, is that a workers' comp client doesn't necessarily know that they've got a claim to make for TPD. And we've described and flagged up front that this could come up in the context of someone suffering from financial hardship because they can't work at the moment. It might be that you're seeing someone with an employment law dispute who's had a workplace injury. There may even be an issue in relation to a bullying complaint or a performance issue. It could come up in the context of issues in relation to disability support pension, or someone who may not even be eligible for disability support pension. And it could come up in the context of NDIS in regard to permanent and significant disability.
Thinking about the psychosocial disabilities, even people on job seeker payment who are struggling with their mutual obligations because of their mental health problems could well be worth investigating.
Yep.
Their eligibility.
So lots of different contexts, I think, to be thinking about the nature of how these sorts of claims could be brought up. There's an important part to this as well that I think is just worth flagging in the context of this, and I might have this because my background, at least at Carroll and O'Day, related to workers' comp. In the workers' comp setting, it's traditionally accepted that you need to select either a physical or a psychological issue as being your primary condition. And from that, you bring a claim that's based on an either or proposition. You can have a secondary claim to make, but you need to choose. In the context of TPD, it really is a whole, these are my words, not anything the insurers actually say, but I think it's a whole of person assessment. And that whole of person assessment really is looking at what their physical condition is, whether they do have any physical ailments that affects their ability to be able to work, or whether they've been forced to leave, but it also relates to mental health issues. And it's the whole of the person assessment really that a TPD claims assessor needs to look at in the context of that. So the next section that we've got here relates to what is TPD as a form of insurance. And I think it's worth just pausing here to sort of lay the groundwork for what TPD actually is. So it is a form of life insurance, and it is for the payment of a specified lump sum, and that amount is on average, I think, $170,000 is what ASIC reports, and it relates to the nature of whether a person has suffered an injury or illness which has caused that person to be incapacitated from their ability to work, and it is going to cause them to be unlikely to ever engage in that work in the future. And so what we know from ASIC's report 633 is that in fact most TPD policy is actually held within what's called the group life insurance cover that the super fund actually holds on behalf of its members. And so the fund goes out into the marketplaces and purchases it on behalf of a class of members, and then holds that cover as what's called default cover on behalf of those. And the insurer is the insurance basis upon which that cover is then claimed. And so just to give you a feel for the nature of what TPD is, unfortunately, there's no simple or easy definition for what TPD is. The most likely, the most common, TPD definition that applies is what's called the any occupation definition, which is the middle definition here on this page, which is where someone is considered totally and permanently disabled due to an injury or illness if they are unable to ever work again in any occupation for which they are suited by way of their training, education, or experience. The distinction that's usually made is between any occupation and own occupation. And an own occupation definition on one version might be considered to be an easier test to meet because you don't need to meet in relation to any occupation, but the particular occupation in which you work.
David, can I just ask a question there?
Sure.
When it's about unable to ever work again, does that mean an older person might have a better chance of getting a claim accepted compared to a younger person?
Yeah, it does come up, particularly in the context of someone who's very young, is that a claims assessor, in the process of assessing a claim, will need to consider whether on balance it's established that that person will be unable to ever work again. And I think that it's fair to say, in my casework experience, that you might see an insurer looking very carefully at a younger person who is disabled, being in a situation where what the insurer might be wanting to see and establish is sufficient medical evidence and information that can be brought that can establish that that person doesn't have that capacity to work in the future. And certainly someone that's suffered a catastrophic injury, that's a young person, of course, would be that situation. But where you've got people that sit in that grey area, what often might happen is that the insurer might seek to have them independently assessed to determine whether or not they do meet that second aspect of that test. And so we, in relation to TPD, there is, of course, further types of tests that apply. Another one is the activities of daily living test, which might, I'm not sure if this looks a little bit familiar in the DSP context.
Yes.
But it's certainly about whether or not there's an ability to meet basic activities of daily living, including feeding, bathing, toileting, and mobility is another one as well.
Yes, that does reflect the disability support pension impairment.
Yeah. And so we know that there are other tests as well that sit in various policies, including home duties tests, cognitive loss tests, and loss of limbs. This is the nature of the any occupation test that's been articulated by the Court of Appeal in a recent case, and we've gone through some of these aspects, but there are certain limbs to this test that are really worthy of thinking about in the context of a client that you might have where you're seeing this sort of issue and you're wondering whether there might be a claim. Really, the operative aspect of the test is the bit really upfront about illness or injury which causes a life insured to be incapacitated. And that's why you'll see in this presentation a reference to illness or injury. The challenge is, I think, for psychosocial disability claims, is it's not really the language of the sector. And my understanding from speaking with a healthcare professional, a GP recently, is that it's not really the language of treating doctors as well, that they're not really in the vicinity of thinking about it in as strict and clear terms as what policies seek to articulate in terms of illness or injury. If we're talking about a mental health continuum, I think it's fair to say that a lot of people may be struggling with their mental health, but the question as to whether in fact they have a mental illness or injury is a question that may not necessarily be that easily answered in the context of these claims. And so certainly what I would suggest is that if you have a client in that sort of vicinity and you're not sure as to whether there is the basis for a claim here, of course it's good to err on the side of testing whether there's a claimable interest, but certainly feel free to reach out if you have to ask any questions. I consider that one of my roles here at Carol and Our Day is to be an available person for the community sector in relation to questions that people might have if they're running these sorts of claims in their practice. And so we've flagged also in the context of this, the second aspect, which is the capacity for work in the future based on education, training or experience. And again, that can be a bit of a challenging thing. This slide will really set up for you if you're thinking about these cases and what they look like. There is some key aspects to it. Usually there is a 6-month waiting period before you can lodge a TPD claim. But that wouldn't mean that if you've got someone who's suffered, for example, a catastrophic injury, that you would necessarily need to wait, and that it can be that in certain circumstances there can be a discretion there in relation to the waiver of that 6-month period. But certainly my experience with the nature of default cover for TPD is that this second link here of the ability to be able to work for a period after the commencement that cover begins, and that's the insurance cover, is a really key element that I think is not really that well understood in the context of TPD. So I'll come back to this in the next couple of slides, because I think it'll play out better if I can give you a practical example. And then a person needs to be ill or injured. We've flagged that under the care of a treating doctor. We know that this can be a real challenge. We would probably see many people, I certainly see it in my practice, where unfortunately, the more unwell they are, it can be that the less likely they are to be able to remain within good care. It's not always the case. I can't make it a categorical statement, but I've certainly seen, I would say that probably 3 of my most disabled clients also seem to be popping out of the healthcare system and not able to retain good practitioners in relation to their treatment. I'm not sure if that's your experience, Natalie.
Yes, I certainly, in the context of people with severe mental health problems, they often don't have insight into their condition,
Yeah,
and are disengaged from the medical system.
yeah, which makes it an extremely challenging and difficult proposition,
Yes,
to be pointing them towards a system that firstly needs to recognise the
Yes.
key fact that they're in denial about. Yeah.
There are some provisions in the social security system that do cater for people who are so obviously mentally unwell and have no insight into their condition, that it might be possible to get those people onto disability support pension without going through the usual hoops.
Yes.
That's quite a narrow exception, but it might be possible, but I doubt that is the case for TPD.
Yeah. And then we know that the tests usually require, these 6 aspects usually sit within most tests, that the trustee needs to form an opinion about the unlikelihood to return to work in any capacity based on education, training and experience. So this is just a reminder again that we're talking about that whole of person assessment. We are looking at the physical and the psychological, and even though this is called, this session is seeking to focus on the psychosocial disability, there wouldn't be many claims in my practice that are purely psychosocial disability claims, in that most of my claims have some dual aspect of physical as well as psychosocial. Although I think it's fair to say that in a lot of the cases that I have where both exist, that usually it's the psychosocial disability that is the key and leading reason why people are unable to remain in employment. Okay, so this slide here is an attempt to sort of give you a feel for what it might mean to have to look at a TPD claim in the context of the nature of cover. And it's not intended to confuse, but I do want to flag for you the challenges that exist if you're looking at these claims, that you might be in a situation where what looks like a good any occupation full cover policy might slip across into what's described as limited cover, possibly even an ADL test, activities of daily living test for TPD. And you may be slipping in and out of these definitions without even knowing it, in that the claims assessor could be looking at and will be looking at both aspects of this most likely at the same time. And so you won't necessarily know that what is being asked and what is being considered is an assessment, firstly, of this provision here in relation to this section 2, about establishing, firstly, that a person that has what's described as default cover can actually meet the requirements of default cover, which usually means you need to actually usually be able to establish that you had some capacity when you commenced in that with that cover to actually perform in the role. And this is just an example. This test at the moment, this slide at the moment describes a 30-hour per week test on a 2-month basis, but we've certainly seen other tests that show 30 hours on a 6-month. You see various different variations of it. And if you can't establish that your client had a basis to work without restriction or limitation up front when the cover first began, which is usually when the member, is when the super fund has obtained that cover on behalf of that member. That's going to be the point at which this assessment will probably flip across into the more restrictive activities of daily living test. And so this is an example of that test in relation to a person with a physical injury and mental health issues. And I can say for certain that in the casework practice that I've got, that if you have a client that has a significant mental health issue, but can do these things to some degree, you will be as equally challenged as I have in establishing those claims in meeting the activities of daily living test. And I think one of the biggest challenges in this area is that, and this was certainly ASIC's comments, was that the product design in TPD doesn't necessarily cater to the nature of the disablement. If we know that if we know that the majority of these claims are actually psychosocial disability claims, why on earth are people being given activities of daily living tests which don't necessarily meet that requirement unless there's some sort of catastrophic injury or illness? It's very difficult to see how these things necessarily correlate in a good way.
David, I just have one question about that slide. What's, just to clarify, the trigger that might move a person into that activities of daily living test as opposed to unable to work in any occupation?
The trigger will be that if you don't actually establish the requirements on the left-hand column here of being able to work for a period of 6 consecutive months, usually it says it might say words like without restriction or limitation. If you can't establish that, they'll say that you're not on, the insurer will say something like, we're not on risk for full cover. And if they're not on risk for full cover, you get flipped across into the limited cover activities of daily living test.
So that's someone who early on in their employment, say, has some injury or...
Yes, absolutely.
Something that causes a significant mental health issue very early in their employment. That's where the problem comes.
Absolutely. It's a key issue if you see that come up. I'm conscious of the time. So the next 2 sections of the slides really then go through the nature of preparing a TPD claim. And the thing that I would say here, if there's a take home here for today's session, it really is this. I think it's thinking about whether you have a client who is ill or injured and whether that has caused them to not be able to remain in employment. There is a correlation and a connection to workplace, because if you can't establish the requirements of that, claim won't exist. And certainly you do need to be able to identify the nature of super cover in force at the date of disablement. It's worth probably pausing here. Sorry, this slide doesn't pick up well the nature of the words that are sitting here, but probably the key concept here about TPD and super is that if you're looking at and trying to work out whether in fact you've got a client that might have had TPD cover, it's worth having a look and asking them to provide for you a copy of their super statement. And on their super statement, what should show up is the nature of whether there was TPD cover in force. Now, the challenge is that if you have a client who left work, as my client did in 2007, and wasn't able to work after that date, what you're really looking for is a historical document that the client may or may not have. Probably a good starting point is to look at a current statement, but the fact that a client may have lost their cover, which is certainly one of the key themes that comes up now in light of the recent government changes to the super policies of the superannuation law, is that even if you've lost cover now, that won't necessarily affect a historical TPD claim. And that's certainly the way that the funds understand that. So here's the process that you need to go through. The key one really identifying the date of disablement, which is the date the person was unable to work due to their injury or illness. And then you'll slide through this claims process that includes the lodgement and inquiries. I'm going to go very quickly through this because I'm conscious of the time. These slides will be here for you to have a look at. If you're in this process and you're not sure where you're up to, you can use these slides here in the context of looking at the nature of how this comes up. I'll just pause on this slide here because it's probably really important to say up front that look, before you lodge a TPD claim, and if you're thinking about doing this work, a lot of the legwork and a lot of the important aspects of identifying the nature of cover relates to the background work that you need to identify in relation to medical, employment and personal information. And that means identifying the nature of your client's treating doctors, identifying where the person worked and what was their last physical date of employment, and also working out when they first became unwell or unable to continue in employment. What often happens in TPD matters is that people make what's called failed attempts at return to work. So if you have a client that left work and then came back into work and came in on night duties and then left the workplace again, that's not necessarily a claim that can't be made. But in terms of the nature of whether the claim will be established will actually depend on the particular circumstances of the policy and the cover in force. So my encouragement is make early requests, just like in the casework, make early requests for documents and information, have a look at the policy, the PDS, and also have a look at the trust deed if you need to in relation to the obligations as between the super fund and the insurer, although that's a less likely scenario. But certainly have a look at the nature of the policy definition that applies, and it's worth doing all of those background things prior to identifying your date of disablement and putting forward your claim documents. These are the claim documents that you need for a TPD claim: 2 reports from treating doctors, employment statement. If you can't get an employment statement, don't worry. Insurers do understand that if you've had a breakdown in that employment relationship, it's often a situation where the employer doesn't respond to those circumstances. And so super funds and insurers do understand that with that breakdown, that should not be an impediment to a claim being properly assessed and considered. The timing of claims is really important. I would always say err on the side of caution in terms of lodging your claim. It's much better to do all of your background information checks, obtaining the information, getting all of that information, instructions up front before you consider proceeding to this process of working with the client for them to complete their claim form and to get the treating doctor's reports. And the more background work you can do on that to help your client, the better position they'll be in relation to it. As Natalie mentioned just before, I think one of the biggest challenges here in relation to TPD work is actually being able to obtain a clear diagnosis and prognosis from treating doctors. And that can be because you've got a client with significant mental health issues that may not have been properly treated for a very long period of time. And someone's going to need to come in and actually make a proper assessment, possibly for the first time in their lives. But you also might have a situation where a client is rural or remote and they simply can't get to treating doctors. And that's something that I think is worth sharing and raising with a claims assessor if you are having challenges in that regard. But probably what I would also say there is, look, if you're having those challenges, you certainly don't want to be going out too early with the lodgement of the claim. It's more important that you can get all of that information early and upfront in relation to employment, information in relation to, health. Lots of issues come up. I want to just take you to this slide. In terms of the claims process, you go through a process of the lodgement of the claim. There's an initial claims assessment. There's going to be a series of further questions most likely asked because all aspects of the TPD test need to be met. And then you'll get to a point where hopefully you're not going to get one of these letters, and it may not be called this. It might be called preliminary assessment, or it could be called something like that. What it essentially is a letter that's flagging that the claim is going to be refused. And if you see one of these letters, and if a client brings one of these in, please note that this is a very important aspect of the process because it's really crucial at this point for the client to provide the information that is actually going to be able to establish the nature of the claim being established. And so one way to think about this is it could be considered that for an insurance claims assessor, they are making at one version an admin law assessment, and that assessment needs to be reasonable and fair. And these words may sound familiar to you in the context of the work that you do, within that context, due process does need to be given. And so if there are information gaps, you should be advised of what those gaps are, and there should be good reasons as to why that information is provided, is going to be necessary for the basis of the claim. But equally, it's worth also saying that if you don't provide that information, it can't be assumed that the claim is going to be approved or paid. And it's a really important principle, I think, of admin law, that a decision does need to be reasonable and fair, but on balance, if the information doesn't support the basis for a claim, you can't expect that an insurer can take steps beyond what are reasonable to identify that information. And so it is a symbiotic relationship between a claimant and an insurer. And there does need to be this dynamic, constant engagement with your claims assessor. And my encouragement would be, once you get to the point of your lodgement and you're in the claims process, is that you do get on the phone to the claims assessor and that you can explain the whole of person assessment that you think best reflects the nature of the diagnosis and prognosis. It's that I think it's these real-time, real-person conversations between people that really are the important conversations where people make connection and understand the nature of people's disablement in a real and genuine way. If your claim's going to be approved by the insurer, they don't say that. The words that will come up are, we have made a recommendation to the super fund. And so the insurer who's doing the assessment will then notify the super fund that the claim's going to be approved. This is all good news for you. The claim will still need to be approved by the trustee. And so the trustee will need to go through steps to establish whether in fact it's appropriate to release the money that's going to sit in the super fund now. And so what will be released is the insurance component. That's probably at least $170,000 plus what's in the super. And so it's the combined effect of the insurance plus the super that is releasable. But whether or not that money is released is, of course, a question for your client to answer as to whether or not they do it. But you will need 2 medical practitioners to certify that if that hasn't been part of the assessment process. And that's just one of the technical aspects here. I'm sorry that it's not here, but I'm just going to go straight to it, that in the context of that assessment, I'm just going to flag here that when there is a release of funds, that there are important implications, particularly for tax implications here, is that unless a person has reached preservation age, currently 59 years, that person will have to pay some tax in relation to it. It's a really complicated tax assessment, and so it can't be assumed, it should be flagged with your client that the super fund and the trustee will withhold that and provide that money to Centrelink, to the tax office in relation to a payment to someone if money is withdrawn. And so it's worth advising your clients in respect of that. And of course, there will be Centrelink implications as well.
And I might just flag there is a fact sheet on the Economic Justice Australia website on impact on Centrelink payments of getting a lump sum payment of whatever kind. Given the time, I'll leave it at that.
Yeah, beautiful. And so, look, I think we've probably I think there's a few questions that we've got. And so I'm just going to quickly flip back to say that there are principles that apply in relation to claims assessment. The notion of a red flag in a claims assessment comes within the context of the duties that sit on the left-hand column there, the duties to assess fairly and in good faith, to inquire and investigate, to ask relevant questions. I'm sure all of these concepts sound familiar. The red flag concept comes up in the context of how AFCA might consider it. And AFCA would say that a claims assessment that doesn't follow these principles may be a red flag in the context of whether duties have actually not been met.
David, you should probably tell people what AFCA is.
Yeah, sorry. Thank you. So AFCA is the Australian Financial Complaints Authority. This is the free, independent dispute resolution body for financial services. So that includes insurance and credit and superannuation. A claim can be lodged there at any stage of a process, particularly it's what's considered to be the usual process is that you'll go through a claim, you'll have a refused claim, and then after a refused claim, you'll seek to try an internal dispute, and then you can go to AFCA. but after a refused claim, it would certainly be appropriate, or it could be considered that you could go into the AFCA process as well. And if you don't agree with the outcome that AFCA applies to your claim, you've got all of your rights and you don't need to accept that decision. Trustee have duties here in relation to acting on behalf of their members that are the best interest duties that sit in the SIS Act. There are lots of issues on relation to red flags that have come up. There is lots of consumer protection laws that apply in this area, including important codes of practice obligations, as well as SIS Act and Insurance Contracts Act. So that's the claims process, and that's the refused claim, the rejected claim process to go to IDR and to go to court. We've talked about that. We know that this is the key aspect that needs to be flagged in the context of this. And thank you. Sorry, there's a lot in that.
Thanks, David. Thanks so much for taking us through that content. There have been a few questions that have come through. So just a reminder that people can type your questions into the question box and I'll read those out. So I might just turn to a few of those questions now. So Simone's wondering whether you know why TPD mental health claims are being refused at such a high rate or a higher rate.
Yes, Simone, it's a really good question. I would say, in my casework experience, this is just my intuitive sense of it. I believe that in relation to mental health claims, I think the biggest challenge is identifying clear diagnosis and prognosis. And I think what we're seeing is a perfect storm of a health system that is running at full capacity and disadvantage and clients that have difficulties in articulating the nature of their disablement. And I think that when people have difficulty with mental health issues, I do think that it can present a lot of challenges for them in terms of being able to articulate for an insurance company and a super fund the nature of their disablement. And I think that without that clear information and evidence to support it, I do believe that what we see in relation to mental health claims is really the reality of the challenges that someone with a mental health issue does face in terms of just their everyday life. I think that dealing with an insurance company and a super fund is going to be immeasurably difficult for someone in that situation. And it doesn't really surprise me to see it at those high levels.
Bridget is wondering if you could explain a bit more about the causation part regarding the phrase caused the life insured to be absent from work. So just clarifying, I suppose, whether the person needs to have left the job because of the injury.
Yeah, it's a really important part of the test. Because we live in a, it's going to sound silly when I say this, sorry, but these are the words that come to me. Because we live in a real world where real people leave employment in various different ways, I think what the courts would say in relation to this is that in terms of the causation aspect of it, is that it needs to be a substantive cause. And I think that within that context, if you have particular circumstances in which a person is challenged because of health conditions and leaves employment, and that is the factual situation that they have left it, if there are particular circumstances where it may have arisen, say within the context of a conflict in the workplace, and it's arguably identified as a performance issue or inappropriate behaviour, that would be a good example for my mind of establishing, if with the right medical evidence to support it, that a person who, say, had a mental health issue and was experiencing mental health issues in the workplace, in fact, has left the employment because their condition is so significant that they can't remain in the employment. But it is a key aspect to it. I would say if you see one of those cases, that you do want to take as much instructions as you can around the nature of the circumstances in which the person has left the employment. But I don't think, even though the employer information is important, I think that the personal and medical information that a person can bring and employment information that your client can bring to a claim is going to be good and useful information to give that context, to give the broader context in which a person may have left that employment. I think that's really important, that the insurer really does get to understand that aspect of your claim.
Jenny's wondering whether with historical claims, are there any time limits?
If you have a claim, so in the example that I gave of my client who had left work in 2007, the relevant assessment that needed to be made there was whether or not there was cover in force at that date. And if there's cover in force and the claim hasn't been made, then time hasn't run in relation to that claim. So there's no time limit issue that arises in relation to those set of circumstances. If you have a refused claim and you're then in a process where you need to make your way into IDR and EDR, that AFCA would say that it's 6 years from the date that you first become aware of your cause of action in relation to a claim, and a cause of action accrues usually when all of the elements of that cause of action have been met. And so it's in relation to these things, I think it's always good and useful to adopt a conservative approach in relation to time limits if you have a rejected claim. But I would say that generally speaking, that in the context of TPD, that because a lot of the circumstances in which this arises relates to claims not being made, the most important aspect of what I can share here is that really, if the claim hasn't been made, then time isn't running. And I think that's a really important aspect of this.
Sarah has a question here in relation to TPD and its interaction with the NDIS. So she's wondering, would a TPD claim impact on an individual's NDIS plan? If so, how? As advocates, she sees issues where a claim outcome may not be as clear as what is covered under that claim. So the NDIA may provide unreliable calculations of compensation and reduce a person's funding. So hopefully that makes sense, but interested in your answer there too, David.
I don't know that David or I are qualified to answer.
Okay.
Experience with NDIS.
Certainly in the context of, so the TPD is a lump sum payment which can be used for whatever purpose is required for the benefit of that person. And so no requirements from the TPD side of it, but in terms of NDIS, my understanding is that it should not be an impediment for that process. I'm certainly happy to work through any issues here in relation to that in the context of the nature of a TPD payment, but certainly to the extent that you have a claims manager in an NDIS process who's misunderstanding the nature of TPD claim and the nature of that payment, that might be one aspect here that could be further considered and looked at. I'm happy to sort of workshop and work through those kinds of issues.
Wonderful. Just still got a couple more questions. We are at time, so I understand if people need to go, but if our presenters are happy to hang around for a few more moments just to answer a couple more questions, that would be wonderful. So an easy one. So this one's from Kylie, just wondering if there's a link to the information about the percentage of conditions before GPs. I think that was very early in the presentation around those stats that GPs are seeing. And David, I know that on the last slide of the PowerPoints, there's a list of references. I'm not sure if that's part of where you obtained those stats from around, what GPs are seeing. You just want to go to that final slide. I think, there we go.
Yeah, yes, it is. That's the second dot point on that slide there that I've got in front of you.
Great. Kylie, there you go. There's your link. So Gillian's asked, is the high rejection rate by Westpac a systemic red flag about problems with assessments by that insurer?
Look, I think that what we're probably seeing in the last few years are significant improvements in the awareness within each of the insurers that are looking at this work, that there just needs to be appropriate care and attention given to the assessment of these claims. And I think it's fair to say that what you do see, generally speaking, is a genuine assessment with the TPD claim by a claims assessor once you get into the detail of those claims. But I think where people bump out of it is that if you do have information gaps in relation to your claims assessment, what you might find, and I'm not making any particular comments in relation to Westpac, but what you might find generally is that if there are information gaps, particular insurers may have particular approaches or considerations in relation to that. I think that what AFCA would say is that you still need to meet those duties, including the duty to inquire. And I think that if you've got a claim and you're having challenges with your claims assessor, with the insurer, there are certainly steps that you can do at a personal level to consider escalating a claim. I've had to do that on a few cases, not often, but I had one claim where it was quite clear to me that the claims assessor didn't understand the information that was before her and had in fact prejudged the claim, including had described the treating doctor's reports as ticker box information. And I took issue with that because I thought that in the context of an insurance claim where we were responding and had followed their processes, that it was really important that the treating doctors that had taken the time to complete those forms, that information had been properly and fairly considered. And I got a tape of that conversation and I shared it with the person's manager. It was not anything malicious. I think that it was just something in relation to the way that that person thought about it. And certainly, I don't know that you can necessarily say one thing about one particular insurer, but what I would say is that if you've got a claim before you and you've got concerns, absolutely raise those concerns. It's not always the case, though, that escalating a claim to a manager will necessarily be the right and best thing to do. And if you want to workshop how you might respond, I'm certainly available to do that in relation to it. But of course, I just want to say finally, of course, absolutely ASIC is available for you if you've got a complaint in relation to a systemic issue. And of course, you can flag that with a code compliance committee that sits with AFCA in relation to breaches of the life insurance code of practice. So absolutely, if you have concerns on systemic issues, please feel free to raise those. They're important things to know about.
Wonderful. So there are still a couple more questions or comments. Kylie's just said that she does NDIS work and they're seeing similar issues in relation to psychosocial disabilities and access. So that's an interesting reflection there as well. And just I might make this the final question, which is hopefully I'm able to articulate it correctly. So are TPD policies a percentage of the permanent disability relating, or does that relate to a percentage of the payout that a person might get? I'm not sure if you might need to explain that question a little bit more, the person who's asked that, who hasn't provided a name. So you might, David, I'm not sure if you're able to respond or maybe just make a pass on that one.
If mental health condition is the most significant part of a TPD claim, does that affect the amount you might get from the claim?
Okay.
I'm just wondering if that's
the
question.
Oh, where am I going? Did we get a response?
No, there's no further. Percentage disability relate to percentage of claim.
Okay, I think so. Yeah, I think it's what Natalie's saying here in relation to two different concepts. So the concept of the cover and the cover and the lump sum cover that you have is quite a separate concept to the nature of your disablement. And so once you meet the elements of the test and you are considered to be TPD, you get the lump sum that's available to you as at that date. And so that's that bit about your super statement and the amount that it says for TPD. So the answer is no, there's no correlation between those two things. But the amounts actually change. So the older that you get, the closer you get to retirement, what you'll see is a sliding scale away from higher cover to lower cover. So less cover as you get closer to your retirement age, because it's intended to protect you for that position.
Wonderful. All right. Well, we might leave the questions there. Thank you so much again, David and Natalie, for your presentation and for addressing all of those great questions that came through from our audience today. So I might just a quick reminder to people on the line to complete the feedback survey that will pop up on the screen once the webinar closes down, which helps us improve our webinar program. And also, in addition to thanking our presenters, I just wanted to also do a shout out to Economic Justice Australia, who is our partner in presenting today's webinar. So thanks all for your time, and thank you to our presenters again for your time and expertise in preparing such a great presentation for us this morning. And we'll see you at our next webinar. Thank you so much, everyone. Have a great day.
Thanks, Carly. Thanks, Natalie. Thank you so much.
David. Bye.
Thank you.